Okay, let's just jump right in with a really striking question. Could the world's most powerful, and you could definitely say most secretive AI system, GPT 5.2, be made completely public?
And not in some far-off future.
No, not at all. We're talking about its source code, all its mechanics, released for everyone to see and use in just a matter of months. That's not a hypothetical. That is the very real legal possibility we are doing a deep dive on today.
And our focus here is really specific. We're tracing the exact legal mechanism and the mountain of evidence in the Musk v. OpenAI lawsuit that could actually force this to happen.
Right. Our mission is to unpack that core claim. The trial is expected to wrap up around August, maybe September.
So very soon.
Very soon.
Yeah.
And the truly astonishing thing is that this potential ruling, it's not based on some new, untested tech law. It's all rooted in a pre-existing contract.
Which is what makes it so fascinating. It's old school contract law driving this monumental shift.
Yeah.
We're talking about an agreement between OpenAI and Microsoft from way back on July 22, 2019.
Almost 5 years ago.
Exactly. And the whole case, this potential order to open source the system, it all comes down to the interpretation of just a few words in that document.
So let's get right to that. The core conflict. Usually when you hear the term AGI, artificial general intelligence, you think of, philosophical debates, consciousness, sentience.
All that sci-fi stuff.
Right. But in the courtroom, the judge doesn't need to worry about any of that. The entire decision just hinges on one thing. Does GPT 5.2 qualify as AGI under the very strict, very specific terms of that 2019 contract?
That is the crucial pivot. It's the legal trigger. If the system is deemed AGI under the contract's definition, this mandatory open source provision just kicks in.
And why open sourcing? Why not just a massive fine or some other penalty?
Because the original agreement was built around a nonprofit, mission-driven idea. The contract essentially said that if AGI was achieved, it had to be shared for the benefit of humanity. It was a safeguard.
A safeguard against one company monetizing something so powerful.
Precisely. So a breach of that core principle, they argue, requires the release of the asset itself. The technology has to be given back, so to speak.
Which makes the definition of AGI absolutely critical. I mean, in the AI world, AGI is always a moving target. But here, the goalpost is fixed. So what does AGI legally mean in this context?
Okay, and this is where we have to be really precise, because this exact wording is the entire legal test. In that contract, AGI is defined as, and I'm quoting here, a highly autonomous system that outperforms humans at most economically valuable work.
Wow. Okay, let's just pause on that phrase.
It's everything.
Highly autonomous. Check. It runs on its own. Outperforms humans. Okay, that's the performance bar. And then the real kicker, at most economically valuable work. So how on earth do the plaintiffs prove that? How do you convince a judge that a system has cleared that bar?
Well, they knew they couldn't just use cool demos or anecdotes. They needed hard quantitative proof that maps directly to that definition. So they introduced one massive piece of evidence, the system's performance on something called the GDPval benchmark.
GDPval. Okay, let's unpack that. When I hear benchmark, I think of, speed test or something. This sounds different.
It's completely different. Think of GDPval less like a simple quiz and more like the AI equivalent of the bar exam or the CPA exam, but for dozens of specialized fields all at once.
So it's not testing trivia, it's testing its ability to generate real, measurable economic output.
Exactly. The benchmark was deliberately built with thousands of tasks from the highest paid, most specialized sectors, things that require real human expertise.
Tasks that contribute directly to GDP, hence the name, I guess.
That's it, GDPval. And the way they structured the data was brilliant because it was designed to speak directly to the contract's definition. It compares GPT 5.2's quality, speed, and cost against actual human experts doing the exact same tasks.
Okay, let's talk scope first. The contract says most economically valuable work. That implies breadth. The sources say the tests spanned 44 distinct professions. What are we talking about here?
We're not talking entry-level jobs.
Yeah.
The list includes things like regulatory compliance analysis, advanced tax optimization, complex logistics modeling, even drafting initial patent documents.
So high-level white-collar work.
Very high level.
Yeah.
The plaintiff's argument is that this broad sweep of 44 professions effectively represents what we mean by most valuable work in our economy.
That sounds pretty powerful, but I have to ask, what's the counter-argument? Surely the defense is pushing back on this benchmark.
Oh, absolutely. And that is the core technical debate happening right now. The defense argues that, sure, the system is good at these very well-defined, clean problem sets, But they say it struggles with the messy stuff.
The messy stuff.
Ambiguity, office politics, interpersonal negotiation, handling a sudden crisis, all the things that make up an actual job, not just a series of tasks.
So they're making a distinction between the intelligence for a task versus the intelligence for a job.
That is the crucial legal distinction they're trying to make. But the plaintiffs just point back to the contract. Their position is, look, the contract doesn't say it has to mimic a human's job experience.
Right.
It just says it has to outperform humans at the work. And for that, they have the numbers.
Okay, let's get to the numbers. What did GPT 5.2 actually achieve on this GDPval benchmark?
This is the critical data point, the central exhibit, really. According to the results, GPT 5.2 beats or ties human experts on a staggering 70.9% of the standardized tasks.
70.9%.
70.9 across all 44 of those valuable professions.
That number is basically the entire case then. It's what turns this from a tech debate into a simple contractual calculation.
It is. If the judge accepts the benchmark is valid, then the whole thing hinges on whether 70.9% legally counts as most.
And there's more to it, right? Because the contract specifies economically valuable work. That's about efficiency, not just quality.
Exactly. It's the whole economic picture. So, two other figures were presented. First, speed. The system operates at over 11 times the speed of the human experts on the same tasks.
Over 11x faster. In any industry, that kind of speed advantage it changes everything.
And then there's the cost. And this might be the most powerful number of all. The system operates at less than 1% of the cost of hiring those human experts to do the identical work.
Less than 1%.
Right.
So the plaintiffs are walking in and saying to the judge, look, this system is better than humans almost 3/4 of the time across dozens of key fields, and it's 11 times faster and 100 times cheaper.
It's a very simple, very compelling narrative. They're basically saying, when you put all that together, the system has, without a doubt, met the definition of AGI that was written down in 2019.
Which brings us to the word itself.
Most.
The contract says it has to outperform humans at most economically valuable work. How do they argue that 70.9% definitively means most? I mean, why isn't the defense just saying most should be like 90% or 95%?
And this is where you see the legal strategy. In contract law, most is often interpreted simply as a majority, anything clearly over half.
So anything over 50.1%.
Pretty much. Since the GDPval benchmark is presented as being comprehensive in its scope of these kinds of tasks, that 70.9% figure isn't just a high number, it's a clear mathematical majority.
So the argument is less about the philosophical nature of AI and more about 70.9 bigger than 50.
It turns a huge debate into a simple arithmetic problem. The plaintiffs argue that once you establish that 70.9% figure, the legal requirement is met. Full stop. The open sourcing is triggered.
But let's play devil's advocate here. What if the judge is persuaded by the defense's argument that the benchmark is flawed?
That's the risk.
If the judge agrees that GDPval leaves out all that messy human stuff leading a team, ethical choices, then doesn't that change the calculation?
It changes everything. That's the defense's main line of attack. They're trying to redefine the denominator.
Redefine the denominator.
Right. They're arguing that the full scope of economically valuable work is much, much bigger than what GDPval actually measures. If they can convince the judge of that, then 70.9% is no longer a majority. It's a minority of a much larger pie.
So that gives you, the listener, the full picture. It's a battle between a hard, quantifiable number and a more holistic semantic argument about what work really is.
It is, but the source material we've reviewed suggests that the quantified argument, the 70.9% figure matching the contract, is seen as the stronger legal path. The analysis seemed to be that the case is, and I think the quote was, pretty straightforward and quite convincing.
So bringing it all home, what does this mean for the immediate future? The ruling is expected around August or September if this mandate is issued.
Then GPT 5.2, the world's most powerful AI, could become public domain almost overnight.
It's just a monumental possibility, dictated not by new laws, but by an agreement signed years ago under totally different assumptions about how fast this would all happen.
And the legal world would be studying this for decades.
So here's the gravity of it for you to really think about. An existing contract could force the open sourcing of a system that's proven to handle nearly 3/4 of specialized economic jobs as well as or better than a human expert.
And it raises this final question for you, the listener, that comes right from the data. The whole legal argument hinges on that 70.9% number. If that's enough to declare the system AGI, enough to say it can handle most work, what does that imply about the remaining 29.1%? the jobs that GPT 5.2 can't do better. Is that the last bastion of human creativity? Or is that just the next target for GPT 5.3?
And think about the immediate practical reality. Forget the philosophy for a second. What happens when a system this powerful, 11 times faster, 100 times cheaper, is suddenly open source? Its power is instantly available to millions of developers, researchers, and yes, bad actors all around the world. The acceleration, the disruption, it would be faster than anything we've ever seen. That's something to think about as we wait for the decision this fall.